On January 20th, 2026, a federal judge refused to dismiss the lawsuit against Texas's sweeping ban on lab-grown meat, setting off a battle between billion-dollar Silicon Valley food startups that have federal approvals and a state whose cattle industry is an economic powerhouse. With the ban and Texas sovereignty still in force for now, the fallout will reach far beyond ranch country. But just how much is really at stake? Inside Judge Alan Albright's federal courtroom, the future of Texas's food laws is now in play. On January 20th, 2026, Judge Albright issued a ruling that instantly shifted the legal landscape. Texas's request to throw out the lawsuit over its lab-grown meat ban was denied. The challenge brought by Wildtype and UPSIDE Foods, two California companies cleared by both the FDA and the USDA, will proceed. The judge found that the claims under the Constitution's Commerce Clause have enough legal weight to move forward. But even as the courtroom drama unfolds, Texas's 2-year ban on selling cultivated meat remains fully in effect. There is no injunction, and there is no immediate change for stores or restaurants. Instead, the case now enters discovery, a process where both sides will dig for evidence, demand internal documents, and question key players under oath. For Texas, this means defending its law line by line. For the companies, it is a chance to uncover the real motives behind the ban. The legal battle is no longer hypothetical. The courtroom has become the arena, and every decision from here will ripple through the state's food industry and beyond. Senate Bill 261 became law the moment Governor Greg Abbott signed his name on June 25, 2025. The statute draws a hard line. For 2 years, no business in Texas may sell cell-cultured meat, real animal protein grown from stem cells in a lab. The ban took effect September 1st, 2025, and is set to expire September 7th, 2027. During this period, any company caught offering cultivated meat faces steep consequences. The law authorizes administrative fines up to $25,000 for every day a violation continues. Those penalties can stack up quickly, threatening to bankrupt smaller ventures and put larger companies in legal jeopardy. Criminal charges raise the stakes even higher. A first violation is treated as a Class A misdemeanor, carrying the possibility of up to 1 year in jail and a $4,000 fine. Repeat offenses escalate to a state jail penalty, with sentences ranging from 180 days to 2 years and fines as high as $10,000. These are not just symbolic measures. The law's language is direct, leaving no room for ambiguity. For the next 2 years, Texas has closed its doors to the sale of lab-grown meat, and the cost of defiance is clear and severe. Governor Abbott's signature on Senate Bill 261 set this legal barrier in motion, creating a formidable obstacle for any company hoping to enter the Texas market with cultivated protein. Wildtype and UPSIDE Foods are the two companies at the center of the lawsuit against Texas. Both are based in California and specialize in producing real animal protein using cell cultivation technology. Wildtype, founded in 2016, grows salmon from fish cells. In May 2025, the company completed the FDA safety review, clearing the way for national distribution. Just 2 months later, Wildtype began supplying cultivated salmon to a sushi restaurant in Austin, one of the first such sales in Texas before the ban took effect. UPSIDE Foods, founded in 2015, was the first company in the United States to sell cultivated meat. Its signature product is chicken grown directly from poultry cells, not from live animals. UPSIDE also passed both FDA and USDA safety reviews, receiving federal authorization to distribute its products across the country. These clearances place both companies among a handful in the U.S. that can legally sell cultivated meat under federal law. Representing the companies in court is the Institute for Justice, a public interest law firm known for challenging state economic restrictions. Senior attorney Paul Sherman leads the case. He argues that Texas is using government power to favor in-state ranchers while blocking out of state innovators, a move he says the Constitution forbids. Sherman points to the Commerce Clause, which bars states from walling off their markets to protect local industries at the expense of national competition. At the heart of the lawsuit is the question of whether Texas can keep out federally approved products simply to shield its own cattle industry. For Wildtype and UPSIDE, the fight is not just about business. It is about whether Texans have the right to choose what they eat. Texas's cattle industry stands at a crossroads, battered by forces beyond the courtroom. The state leads the nation with 12.2 million head of cattle, a figure that once symbolized stability and growth. Today, that number hides a sharper reality. Years of relentless drought have pushed herds to their lowest levels since 1961. As of January 2026, 91% of Texas faces dry or drought conditions. Ranchers watch their pastures wither, water tanks dry up, and feed costs soar. The industry's economic footprint remains massive, over $13 billion a year, but the foundation is eroding. In Amarillo, Tyson Foods announced 1,700 job cuts at its beef processing plant. For workers and families, that means paychecks vanish and uncertainty grows. The pain radiates outward, from feedlots and processors to small-town businesses that depend on ranching dollars. One rancher near Abilene described the mood as anxious and defensive. He said he was not just fighting weather. He said he was fighting to hold on to a way of life handed down for generations. The introduction of lab-grown meat is viewed by many as a new threat, arriving at the worst possible moment. With cattle numbers shrinking and jobs on the line, any challenge to traditional beef feels personal. The legal fight over cultivated meat is not just about market competition. It is about survival for thousands of Texans tied to the land. Sid Miller, Texas's agriculture commissioner, wasted no time responding to the federal court's decision. He called the ruling an assault on Texas ranchers and accused the judge of handing a gift to Washington elites and a slap in the face to state sovereignty. Miller's words carried the weight of a state already on edge. He did not hold back, warning that lab-grown meat isn't progress, it is a Trojan horse. In his view, the lawsuit threatens rural livelihoods, risks food safety, and undermines trust in the food Texans put on their tables. Miller pointed to the financial backing behind the challenge, labeling Wildtype and UPSIDE Foods as leftist, Bill Gates-backed startups, and painting their products as the latest scheme of billionaires, not the future of food. Texans don't want meat grown in a petri dish and marketed by billionaires. They want real beef from real ranchers who raise livestock under time-tested standards. Texas will not be bullied. We will not back down. Senator Charles Perry, who authored the ban, echoed these themes in public statements, insisting the law would support traditional agriculture and arguing that Texas's farmers and ranchers deserve protection during times of uncertainty. The Texas Farm Bureau, the state's largest agricultural organization, framed the 2-year ban as a reasonable window for additional research, positioning the law as a precaution while science and public opinion catch up. These public statements set the tone for the fight ahead, defining the legal battle as not just a question of commerce, but a test of identity, tradition, and who gets to decide what is on the Texas dinner table. Both sides now brace for discovery, a legal scavenger hunt that could decide the fate of Texas's ban and ripple across the country. Attorneys for Wildtype and UPSIDE Foods are preparing targeted requests for legislative emails, internal memos, and draft versions of the law. They will seek every red line, every communication between lawmakers and industry groups, and any internal analyses that weigh economic protection against food safety. The goal is clear: uncover evidence that the law was crafted to shield Texas ranchers, not protect consumers. If a single email or floor statement reveals a protectionist motive, it could tip the balance under Commerce Clause doctrine. Texas, for its part, is expected to demand federal safety records, inspection reports, and consumer complaints about cultivated meat. The state will try to show it acted out of caution, not favoritism. Both sides will likely fight over privilege claims, whether certain legislative communications can remain secret or must be disclosed as evidence of intent. That fight over documents and depositions could last months, possibly years, as each side hopes to find a smoking gun. But the impact will not stop at the state line. Texas is one of 7 states with active lab-grown meat bans, joined by Florida, Alabama, Mississippi, Montana, Indiana, and Nebraska. A nearly identical lawsuit is already underway in Florida, creating a coordinated legal front. Any ruling in Texas could set a precedent, forcing all 7 states to reconsider their bans. As Paul Sherman, the plaintiff's lead counsel, strategizes for the months ahead, the stakes extend far beyond one courtroom. The outcome here could shape how and whether cultivated meat reaches Americans' plates from coast to coast. As federal courts weigh the future of food and commerce, Texas's fight tests where state power ends and national innovation begins. With 7 states now banning lab-grown meat, the outcome here could redefine what Americans are allowed to eat and who gets to decide. What do you think?